Welcome back to the Making International in Korea video series. In this video, I'll be explaining on Article 3 of the Constitution of the Republic of Korea. South Korea considers North Korea as an illegal group with a non-reclaimed area. Article 3 of the Constitution of South Korea states that the Korean Peninsula and its adjacent islands are the territory of South Korea, which connotates that North Korea is under the national jurisdiction of South Korea. In 1993, the Constitutional Court, in unconstitutionality of the Article 3 of the Inter-Korean Exchange and Cooperation Act, decided that at the current stage, North Korea is a partner to facilitate dialogue and cooperation for the realization of the peaceful reunification, but at the same time, possess the characteristics of an anti-government group that plot to overthrow the liberal democratic government of South Korea. In the same vein, the Supreme Court ruled in case which is delivered on September 25, 1990 that the court cannot predicate that North Korea is not an anti-government that infringes territorial rights of the Republic of Korea. Although statehood North Korea is recognized by the international community and our government is proposing summit to the North Korean authorities, we cannot approve any type of government that conflicts with the sovereign rights of the Republic of Korea. Since then, there have been a series of domestic court decisions that supported the view of the Constitutional Court of South Korea. Overall, the South Korean court conveyed the view that the North Korea is a group that conflicts with and infringes on sovereign rights of South Korea. Furthermore, South Korea resorted to United Nations General Assembly Resolution 1953, which is to provide the ground for her legitimacy, since the resolution declared that South Korea was able to establish a lawful government in which the majority of the people of all Korea reside, and based on the elections which were valid expression of a free will, and that this is the only such government in Korea. Also, she considered that such legitimacy have been confirmed according to Article 3 of the Treaty on Basic Relations between Republic of Korea and Japan, in which it stipulates that it is confirmed that government of the Republic of Korea is the only lawful government in Korea, as specified in the Resolution 1953 of the United Nations General Assembly. Overall, the South Korea maintained the position to consider it as the sole government that has been recognized by the international community, while North Korea is a mere anti-government group within her jurisdiction. In contrast, North Korea regards South Korea as a puppet regime. Article 1 of the Socialist Constitution of North Korea states that North Korea represents the entire Korean people throughout the peninsula. She further finds the legitimacy from the North Korean parliamentary election held in August 1948. In this sense, North Korea harshly criticized the introduction of the Korean question at the United Nations in 1947 because it was intended to realize the invasion of Korea by the imperialist United States. In other words, North Korea claims that South Korea cannot be acknowledged as a legitimate contracting party whatsoever in international law due to the absence of the independence. Let me touch upon the state succession of a unified Korea. Since 1948, two Koreas have continuously been challenging each other for the legitimacy of the government, arguing that their government solely represents the interests of the all Koreans. Whereas the North Korea finds its legitimacy from the North Korean parliamentary election held in August 1948, South Korea resorts to the General Assembly Resolution 1953, as it connoted that the government of South Korea was the whole lawful the government in Korea. Such was clearly reflected in both Constitution of South Korea and Socialist Constitution of North Korea. Despite the lack of recognition of one another as a legitimate government, both Korea and North and South Korea have maintained the position to achieve peaceful reunification as a common promise. Furthermore, identifying their relations as a special interim relationship stemming from the process toward reunification based on the 1991 Inter-Korean Basic Agreement, the two Koreas have been entering into treaty relations with each other, which can be referred to as an act of international person. Accordingly, the discussions over state succession in the process of the reunification have brought about two questions to the surface. The first question is whether state succession of a unified Korea can really occur or not, and this is because the state succession itself an interstate phenomenon. The second one is what kinds of obligations should be succeeded if the state succession can take place. From the domestic fora, however, these questions were not able to be addressed properly, as it is difficult to clearly define the legal statehood of the both Koreas. Overall non-recognition both by South and North Korea gave rise to the question of whether state succession can occur based on the international law in the first place, and if that so, what kinds of obligation should a unified Korea succeed? Given this question was not a matter of domestic but of international concern, it is necessary to review that the state succession of the unified Korea from an international context, specifically the United Nations, where the Korea question has been addressed most effectively since the independence of Korea. The Resolution 46-1 granted Korea's membership of the United Nations in 1991. It implies that such international agreements can be considered as a recognized statehood both South and North Korea. But at the same time, this should not be interpreted as a permanent position, but a temporary one, as the resolution have consequently and constantly reaffirmed the objective of UN is to establish the united, independent, and democratic Korea under representative form of the governments, and the realization of such is in accordance to the purpose and principles of the UN Charter. State succession of a unified Korea is not a simple problem that can be resolved easily. However, the discussion of Korean question at the United Nations provide meaningful insight and factors to be taken into consideration. The implication becomes more complex considering how the two Koreas are to be unified. The first consideration lies with the obligation to follow should the effort toward the unified Korea succeed. Since South and North Korea are state parties to different bilateral and multilateral treaties and possess external investments and debts to various countries, the succession of treaties and obligations should be carefully examined, not only to secure the benefits of the peninsula, but also to prevent external disputes. At the same time, there exist treaties that would be terminated in the process of the incorporation due to the political nature of the treaty that has been concluded between North and maybe the socialist states. But whether to terminate such treaties automatically or gradually need to be further negotiated. Second is how such obligation can be succeeded, or the methodology in succeeding the trade obligation and responsibility of the predecessor states. More importantly, there have been discussions on the applicability of the 1978 Vienna Convention on the Succession of States. Through neither South nor North Korea is a state party to the convention, some domestic scholars maintain that the convention assumes all types of the unification models. On the other hand, some argue that there is no specific clause referring to state succession in the case of the divided states. This, in turn, has further led to the discussions on the existence of the customary international law regarding state succession and whether such has enough state practice to be considered as custom.